Good morning, this is your Kelso Report for Thursday, August 9th, and I'm your host, Clark Kelso. We begin with a criminal sentencing case, Ninth Circuit. The defendant in United States v. Huang pled guilty to conspiracy and possession with intent to distribute various quantities of methamphetamine, including one quantity of more than 900 grams. The district court sentenced the defendant to 135 months in prison. He appealed on the ground that he was the victim of sentencing entrapment, which occurs when a defendant is predisposed to commit a lesser crime, but is entrapped by the government into committing a crime subject to more severe punishment. Well, the Ninth Circuit affirmed his conviction and sentence, concluding on the record that the defendant had both the intent and the capacity to produce more than 900 grams of methamphetamine. That wasn't supplied by the government. And he acted on that intent without hesitation. He was, in other words, predisposed to commit the bigger crime. Next, we turn to an interesting remedies problem in California state law. One of the benefits of dealing with a licensed real estate broker or agent is that if you successfully secure a judgment against a licensed agent and the agent is unable to pay the full amount of the judgment, you can recover some or all of the unsatisfied amount by claiming against the state's recovery account, which is administered by the Department of Real Estate. Now, in order to qualify for payment from the recovery account, the judgment must be one that is based upon the defendant's fraud, misrepresentation, or deceit. In Worthington v. Davie, the plaintiffs secured judgments against their broker based on 4 allegedly fraudulent real estate transactions. When their judgment against the broker was unsatisfied, they applied to the Department of Real Estate. The department granted relief for only one of the 4 transactions, denying relief on the other 3, reasoning that the claims in those other 3 involved breach of fiduciary duty instead of fraud, and therefore did not qualify under the statute. The 4th District Court of Appeal reversed, concluding that the other 3 claims involved a breach of fiduciary duty, but that breach was itself based on intentionally fraudulent misrepresentations, and that was sufficient to trigger the payments from the recovery account. Next, we have a class action case under the unfair competition law. The plaintiffs in Tucker v. Pacific Bell Mobile Services alleged that the defendant wireless telephone companies made material misrepresentations to the consuming public as to the actual number of usable airtime minutes in advertised subscriber rate plans because of the defendant's practice of rounding up used minutes. The trial court sustained the defendants demurred to the class action allegations without leave to amend, relying largely upon the California Intermediate Appellate decision in Knapp v. AT&T Wireless, which involved nearly identical allegations. It was a lawsuit brought by the same plaintiffs' counsel. The First District affirmed the dismissal of the claims for fraud and claims under the Consumers Legal Remedies Act. As to these claims, the facts were virtually indistinguishable from Knapp, and the problem was that the purported misrepresentations were communicated to class members through a variety of written materials, through the mail, via the internet, by telephone, in retail stores, orally, and in some cases, there was no misrepresentation at all. These causes of action also required a showing of materiality and causation, and it was clear to the court that that would involve the court in examining thousands of individual class members. So as a result, common fact questions would not predominate, and class action treatment was therefore inappropriate, even judged at the time of a demur. Now, when it came to the claim for equitable relief under the unfair competition law, the First District here held that the case could proceed past the demur stage. The differences were that the relief was limited to equitable relief instead of damages, and the unfair competition law cause of action is broader than just common law fraud. In addition, the court noted that the case arose at the demurrer stage, and the court was not intending to hold at this point that the case could in fact survive a class certification analysis. So the parties will go back to the Superior Court to develop the facts a little more and duke it out over class certification of the unfair competition law claim, where relief would be limited to injunctions and the like. Next, a choice of law decision. When a litigant attacks its own choice of law provision in a form contract which it has written, you know something has gone terribly wrong. But that's the scenario which confronted the 3rd District in Maxim Crane Works versus Tilbury Constructors, where the trial court enforced against the plaintiff what turned out to be an unfavorable choice of law provision in a form contract written by the plaintiff. An employee of the defendant was injured on the worksite and sued the plaintiff for personal injuries. The plaintiff then cross-complained against the defendant, seeking indemnity. Both were contractors working on the site. The plaintiff's construction contract with the defendant contained a choice of law clause specifying that Pennsylvania law, the home jurisdiction of the plaintiff company, applied. Now, under a quirk of Pennsylvania law, turns out the trial court found that the indemnity agreement in the contract would be inapplicable to the employee's claim. That was why the plaintiff then could be found attacking its own choice of law clause on appeal. The 3rd District rejected the plaintiff's argument since the plaintiff was a Pennsylvania company, and the contested issue, which was the applicability of the indemnity clause to allocate loss associated with the employee's personal injury claim, was not one about which there was any strong California public policy. And the rule is that so long as a choice of law clause does not produce a result contrary to some fundamental California public policy, and about which California has a materially greater interest than another state, California courts will uphold and enforce a choice of law clause as representing the reasonable expectations of the parties. As the 3rd District noted, the plaintiff in this case was hoist by his own petard. And that's it for today's Kelso Report. Have a great day in the law.